Good morning, Bruce. Thank you for talking to me about your recent victory. But before we get into that, just tell me a little bit about your practice.
I'm a trial lawyer representing injured people in more serious type of crashes and other events causing injury.
Okay, and so we've worked together really two times that I recall. And you recently made me really happy when you called me up and you said you were able to settle the case and you were able to use the results from our online focus group. So, my first question to you is what made that case a candidate for an online focus group?
The case was a little out of the ordinary. It had both liability and damage issues that were outside the norm that we usually cover. I thought a focus group with more intensive study on those issues would help benefit the presentation of the case, the potential settlement of the case, and certainly if we were to try the case, it would come in handy.
Okay. And I think you had said something about, value was it was really hard to figure out what it was worth, and you had gotten some opinions from your colleagues. Tell me a little about that.
I had reached out to other fellow trial lawyers to do a roundtable and was able to provide some materials to them and had a roundtable for about an hour. The results of it were quite disappointing. The value that they thought was much, much lower than we had anticipated for the case and was disappointing. So the next step to undergo was to see with more intensive market research like you do in your focus groups, how the case would be reacted to by jurors from the area in which we were trying the case.
And then so we did go through that process together. And tell me what was eye-opening to you about the results?
The eye-opening part was liability was much stronger than we had thought. The damages aspect was quite a bit higher in value than even I thought. And the drivers of the damages were surprising. The drivers were the extensive negligence of the defendant and not so much the injuries that we were able to work up, brain injuries, PTSD, the more silent type injuries were not the driver of damages, but the negligence turned out to be a significant driver, which was the surprise.
And tell me about your opportunity to use, a lot of lawyers, I always want them to be able to go to a mediation with ammunition so that they can get a settlement that's way up there. Tell me how you were able to actually do that.
Before the mediation, I had had a number of discussions with my opposing counsel about the fact we had conducted a focus group and that liability seemed strong. At the mediation, with the adjusters present, I was able to explain out of 15 people that we had presented the case to, 11 thought that the negligence was substantial. I think 7 were very negligent, and 4 were negligent, with very few being either not negligent or somewhat negligent. And so the gradations of the focus group with how negligent they were tipped heavily towards significant liability issues and fed into the damage aspects. And I was able to explain that directly to the adjusters and to the mediator during the opening public session of the event.
Okay. And usually, opponents want to poo-poo results like that. Yeah, you had people into your office, you strong-armed them, you fed them Panera. I'm not interested. Why was it different for you? How could you overcome those objections?
I got exactly that kind of response. And what I did was just let it sit for a few days or a week. I then sent my opponent leading up to the beginning of the mediation, your write-up from your website on how you conduct a focus group. Unlike what he had described to me, which is an in-house mock jury, you gather 6 or 8 people and you conduct an event. This is really market research, the kind of focus group that you perform. It tests issues, it tests gradations of issues. It's like a grade. You get A through F on almost every issue. And then after they answer the question, they have to give an explanation of why. So that was instructive, and I was able to explain to my opponent that this focus group was unlike any of the mock jury types that are conducted in-house and were done at significant expense to get reliable and proven results.
And what about, I think you had said you shared it with the you shared the data points with the mediator, but not the actual data points with your opponent. Tell me how that,
I
whether
gave,
that had an impact.
yeah, I gave him two parts of it. I gave him the gradations of negligence and the array with the responses in writing that the focus group participants gave. I then informed him of the extensive debriefings that you do that gave me a lot of tidbits of information to see what drove them to decide as they did. And I gave him some information on the damage aspects, on how the array shook out with the damages. So and so, such an amount was in play, although unlikely. There was a sweet spot, and then much lower seemed to be a given. So we were starting with a base and going up from there. And that had an
Okay.
impact on him, and he was able to use that during the mediation to push for what we believe was a very satisfactory, highly satisfactory result.
Okay. And how did it compare to what your colleagues had predicted in your roundtable?
The colleagues were throwing a lot of shade. They saw only the problems. Um, and they did not give as much weight to the negligence that we had claimed had occurred. The focus group focused so much on the negligence that it became a driver for everything else in the case. And so the roundtable was in a much lower range, and we settled for significantly more, like add a 0 or 2 more.
Okay. And I don't want to put words in your mouth, but when you first called me about the case, you didn't seem that enthusiastic either. Did the online focus group change your view?
Much so. I was able to use it with confidence. I was able to know the issues that were critical to the participants, and I was able to leverage that both in my trial preparation and in my mediation memo to get ready to present this case in a fashion that I felt confident would tap into the beliefs that the jurors would have about different issues in the case. And so I felt better armed, I felt more confident, and I felt bolder in making my case.
And do you think you could have settled it at that number without, coming to the mediation like most lawyers do, just talking about the strengths and relying on the mediator?
No way. The other side placed so much emphasis on liability that they felt they had a very good chance of defeating the case outright. The focus group showed that more than 2/3 found it to be very negligent or negligent, with even the people who had been less enthusiastic about the case being debriefed, and I got to hear why. So I was bolder. I was much bolder in how I presented my case and how I forcefully argued that they believed liability was an issue, but we did not. And I was even able to explain to the mediator that their liability position would probably come back to haunt them because of the feedback we got from the focus group. Their expert played into the harm that the potential jurors, the focus group folks, thought was so important. So I thought it would come boomerang against them.